Hello everybody, and thank you all for joining us. We're back here at our weekly AMA, Ask Me Anything live stream, where we try to answer all of your legal questions, COVID related and not, all condominium law questions. As I said many times before, why do we do this? We started doing this because of the COVID-19 pandemic. In our business, everybody is dealing with each other usually, and in the past, on a regular basis. We have a lot of board meetings, condo meetings, discussions with managers, discussions with trades. Managers are always involved with auditors, lawyers, contractors, etc., as are boards. And basically, because of the pandemic, everybody went into hiding. And we thought it would be a good idea to have these weekly live streams so that everybody could somehow keep in touch, keep in contact, and get some information on condo law while we're all at it. So this is how it started. Happy to say, as everybody knows now, effective midnight last night, or midnight coming into today, June the 24th, Toronto has finally and famously gone into stage 2 of the opening of the province of Ontario, as has Mississauga, Peel, Brampton, etc. I think the only area right now that is still in stage 1 is Windsor, Ontario, unfortunately, and hopefully things will straighten out there and they'll be able to come into stage 2 as well. So I was planning to have a big surprise for everybody today. Stage 2, I was going to come with a haircut, but there's no such luck because I think a lot of people had the same idea. And so if you want to get a haircut, or if you want to get your roots colored or whatever, you need to make an appointment now. Not with me, I can only give you condo advice, but with your hairstylist. And I think it's going to take 4 weeks until they start seeing a relief from the backlog that ultimately they're going to have. So that's issue number 1. Welcome to the live stream. Number 2, as you know, we send out a COVID-19 FAQ, frequently asked questions. So we send that out. We used to send that out every Monday, but then Premier Ford decided that Mondays at 1 o'clock he would be giving his COVID announcements. So we moved our date from Mondays. We send it out now on Tuesday so we can be as current as possible based on what the government says on Monday. So you get it on Tuesday. It's full of footnotes to source material. And so you can read the FAQs. You have all your answers there, as well as the source material in the footnotes. In addition to the COVID-19 FAQ, we do a case law corner, and the case law corner is something that comes out every Friday. We have our lawyers in the office. They do a short 2 to 3 minute video on an up-to-date and current condominium case. That goes out every Friday with a summary and, as I say, a short video. So if you're a condo manager or a director, a unit owner, or just somebody who loves condo, it's a good place to go to see the videos. You can go to the YouTube channel and you can click on the appropriate link and you can see the cases. We can also send them out to you if you want on a weekly basis with our email blasts. And we also do what's called a condo spotlight, and we've done one of them so far. That is when one of our lawyers will interview someone in the condominium business, someone in the condo industry that has a special talent or a special service that they are providing. So the first one we did was hosted by Bradley Chaplick, one of our senior associates here, and he interviewed someone who runs a cannabis dispute resolution center. So if you have any type of issues with smoke related to cannabis or smells related to cannabis, this is a resolution center that you can use to assist in a mediation. And that's something that is new, something that I'm sure as time goes on with cannabis being legal is going to be more and more useful to everyone. So what's happening? We started today, stage 2 for Ontario, and that means a lot of good things for people. We're going to answer some questions first, but I will tell you the million-dollar question is, can we go and use our swimming pool in our condo? And I'm happy to say that the answer is yes. The swimming pools are now available for use, whether they're indoor pools or outdoor pools. So that's a great thing. However, you must keep in mind that with the opening of the pool, and along with other things that are open in stage 2, you must remember that you have to practice your social distancing of at least 2 meters between people, and you have to wash your hands frequently and sanitize the area where there's heavy usage touch surfaces. So it's not we're opening our pool and we're having a good time, we're going to have a party now. No, we're going to open our pool and we're going to be very careful about our social distancing and the sanitation situation around that pool. So it's a good thing pools are now open. It's a good thing for kids. Splash pads will be open, or are open as of this moment. As far as indoor gyms, they continue, and indoor amenities, they continue to remain closed. The outdoor amenities can now be opened, again, always with social distancing, frequent hand washing, sanitation stations, etc. So what we need to remember is, even though we're in stage 2 and we can now go to a patio in a restaurant, outside patio, you still need to be very, very careful. The good thing, of course, we've gone from social settings that where there used to be a maximum of 5 people in a social setting. We've gone up to 10 now, so that's great. There's also a provision for weddings and religious ceremonies, and unfortunately funerals, where the amount of people have allowed in the venues have gone up. So if you're going to have any type of ceremony, etc., in an enclosed area, it's you have to have a usage of a maximum of 30% of the indoor area, and if you're going to be outside, you can have a maximum of 50 people there. So let us get to some questions here. Sally Norman, can I ask a question here? You may. I don't see your question, so please send it in. We have a hello from Julia Laurier. As you know, Julia is one of our great associate lawyers who is at home now with her 2 children, her little baby and her little toddler. And I say hello to them. I'm sure they're watching, because just like their mom, they want to become great condo lawyers. Ain't that the truth? Now, Paulette Forsyth. Whoa, stage 2. What about the sacks? Well, I promised the sacks, and I didn't do it yet. So I'm going to make a commitment now. I do this live stream every week. The week after me, I do it once a week. Brad Chapik does it the next week. So Brad's doing it next week, and I'm making a firm commitment now that the week after, I'll play my sax. Okay? Done deal. And you can hold me to it. Harlan Stavis. There an advantage to living in York Region. Oh, ho, ho, had my hair cut, thank goodness, last Friday. So Harlan was someone who sent us a chat question last week. It was about him getting a haircut, and he was worried that he still might not have enough hair to get a haircut. But I'm glad to see that you were able to convince the barber to give you a haircut in York Region. So here we are in Toronto. We'll be next in line, that's for sure. Harlan Stavis, now he asked me a serious question. If the only access to the pool is through a change room, which is an indoor amenity, are we able to open the change room? Well, this is a great question, because the answer to that is yes. You are entitled to open up the change room, have use of the change room and the shower with respect to the pool. So people can change in the change room, they can take a shower in the change room, providing this is a accessory or as part and parcel of using the pool. However, please note that saunas, whirlpools, and that type of thing are still not allowed to be open. And if you're going to be using the change room, you must, again, it's on a condition. All of these things have conditions. And the condition is that you use social distancing, that you ensure that there's proper cleaning and disinfecting of the area, and that you follow the public health authority directives with respect to that. So the various jurisdictions have now put out pamphlets and very excellent information booklets that you can download them, and they're called basically How to Open Your Pool. And I have read an excellent document from York Region, How to Open Your Pool. You can either go to the York Region website, or if you can't find it, you can always email me. I've got it in a soft copy, and I can send it off to you, and it sets out everything you need to do to open your pools. And remember, very importantly, social distancing, as I said. So you have to think about this carefully. If you have chairs that are on the perimeter of the pool, you have to ensure that those chairs are at least 2 meters apart, because the people who sit in them have to be at least 2 meters apart. You should consider perhaps taping lines between the chairs so that people don't move the chairs. What you do want is to keep your social distancing. Again, that is the law in Ontario. We have spoken about this before in other live streams that we've done. There are significant penalties if you breach the orders, if you breach the emergency orders of the province of Ontario. There are significant penalties to the management and to the resident and to the corporation. It's not a place where you want to be. Next question. Debbie Pfefferman, a great condominium manager, I must say. How do we determine how many people are allowed to use the indoor pool at one time? So again, you have a number, a load level for your pool, at the maximum amount of people. You have to ensure that there is, within that maximum amount of people that can use that pool, you have to ensure that there is social distancing. Some condo corporations, what they are doing for those pools where they haven't had an attendant or a lifeguard, are hiring lifeguards. And I know there's an additional cost, but they're hiring lifeguards, and they're going through with the lifeguards, management is going through with them exactly what the protocols are for opening up the pools. So you need to establish the protocols. You need to educate your owners. The responsibility is going to fall on not only the residents, but it's going to fall on he who controls the management of that pool, and that would be the corporation and property condominium management. So again, as I said, I know that York Region has a wonderful booklet on how do we open our pool. I'm sure the City of Toronto does as well. We can send that off to you if you want to email us. All the protocols will be there, but social distancing, sanitization of changing areas, of high-touch areas, all these are the conditions on opening. You cannot have more people in your pool than would be greater than the allowable level of people for that size pool. But then again, you have to keep a control of the amount of people in the pool to ensure the social distancing of at least 2 meters. Very, very important. If you don't do that and somebody calls, regardless of the penalties, and if somebody calls the health authorities, they can come and shut you down. Next, Sally Norman. Can I ask a non-COVID question? You absolutely can. And I'm going to go down the list to see you asking that question, and I see you here. I'm a property manager, and I have been experiencing picking on me and derogatory comments from my supervisor, especially when she referred to my English language skills and my origin. What can be done about it? Well, Sally, picking on you and derogatory comments are not part and parcel of what you signed up for in your occupation. And so I would suggest to you that your supervisor actually needs to take a course in human relations, obviously. Your supervisor should try another business, obviously, where there are other people not involved. I would suggest that you speak with if you can, you need to speak to the head of the company there, the owner, the president, and bring the situation up to the president. You have legal rights, and your supervisor, that would include your employer, is in breach of the occupational health and safety obligations and other obligations under the Employment Standards Act. So, I wouldn't tolerate, if I were you, what's going on there. It's not what you signed up for. Next question here. Property manager. If the corporation has no standard unit bylaw and a leak occurred in the kitchen pipe, who is responsible for repairs, including the flooring, for about $30,000? The corporation insurance deductible is $10,000. Wow, I want to cry when I hear stories like this. So there's no standard unit bylaw, the leak is in the kitchen pipe, and the damage is to the flooring. So the question is this: you need to, if you don't have a standard unit bylaw, then there are two competing cases out there. One case says if you don't have a standard unit bylaw, then everything would be standard in the unit. If everything is standard in the unit, the condo corporation insurance covers the basic unit and the common elements. And if the flooring is deemed to be part of the unit, that's part of the responsibility for the insurance company for the condo corporation. Now, your deductible would be $10,000 and the flooring damage is $30,000. So what I would suggest is to go through the insurance in that example, and you would have your $10,000 deductible. There is also a provision in the Condominium Act that would allow a corporation to charge back the deductible, the lesser of the cost of the deductible and the damage to the owner that caused the damage. So that's something there that it looks like you'd go through your insurance company. It looks like you would be able to charge back the deductible of $10,000 back to the unit owner that caused the damage. But again, we'd have to look at your corporation bylaws. That's one of the things we'd have to look at. Now, if there's another case that says you have to look at all the surrounding circumstances to make a determination if something is standard or not, in the event you don't have a standard unit bylaw, so that again, it would have to require further investigation. But the bottom line for you is that you didn't have a standard unit bylaw, the corporation doesn't have one, and for situations like that, you absolutely need to draft one and get one in place so that you don't have the issues as which insurer covers the damage. Going forward, there is amendments that are supposed to be coming into force with the Condominium Act, dealing with what happens if you don't have a standard unit bylaw and setting out what would be standard. But that is going to be a general provision which may or may not be satisfactory to a unique condo corporation. And so my suggestion is to tailor your own standard unit bylaw based on your condo corporation. Next question. Mariam Jalali. Hello, Brian. As one of the problematic buildings, which has mostly tenants who do not follow any rules, especially social distancing, can the board decide not to open the amenity? Well, Mariam, you have a problematic building. So I guess what I'll say to you is join the club. Join the condo club. There's a lot of problematic buildings, although there are some excellent ones as well. I'm going to suggest that if a specific unit owner or owners do not follow the social distancing protocol, which they must, they should be prohibited from using that specific amenity. If you're not able to control the situation because there's a tremendous preponderance. There's so many people not following the social distancing. At the end of the day, I think your only course of action would be to close the amenity. But I would try to send out a notice to the owners. I would try to educate them. And I'm sure that everybody's saying in the back of their minds now, my goodness, we send out notices to owners. They never read them. We can't educate these people because they don't want to be educated and they just want to do what they want to do. So wanting to do what you want to do is an issue for people who should not have bought a condo. If you buy a condo, you have to understand it's community living, and there are certain things that you give up when you have community living, but you do get a lot of good things as well. So to get back to you, Marianne, I would send out specific note, a letter, a compliance letter from management. I would follow up with a compliance letter from the lawyer. I would advising them of their breaches, the dates of their breaches. It would be good to have incident reports from security. And if all of that is not going to assist them in changing their behavior, and if this is something that is a building-wide issue, I would then consider closing the amenity. Next, Leo Alvarez, let's chill out, Saks on July the 8th. Okay, so I've agreed, I've committed, and I'm going to have a big show for you guys. Not next week, but the week after. So tell all your friends that Horlick, he's going to actually do it. All right? Paulette Forsyth, regarding the pool, what about the maximum of 10 persons? Does that not apply? So the answer to your question is the 10 persons are for certain things, and I'm going to just tell you what. Okay? So the maximum of 10 persons are for an organized public event, a social gathering, and a gathering for, religious services, etc., which has been now expanded as well. So pools are not within the social gathering provision of the regulation. So you can have more than 10 people in the pool. But that's an excellent question. Very good question. Catherine Gow. Well, Catherine Gow, super manager. She was so good at managing that they made her a regional manager. So I hope you're happy now. You should have never done such a good job. You'd still be a great senior manager. We wouldn't have to supervise all those buildings. Catherine Gow, great point, Brian, on being able to ensure there is physical distancing being observed, particularly given Toronto's experiences at Trinity, Bellwoods Park, and the beaches upon opening. So, Catherine, that's a great point yourself, because there's been a certain amount of disappointment from, I guess, not only the government, but from the people in Ontario in general who have tried so very, very hard to do social distancing, to wash their hands, to close their businesses. Some people are in terrible, desperate financial condition, all to make sure that we together fight as best as we can this pandemic. And then you've got these, what they call COVIDiots, who think it's okay to go to the beaches and have a party and have beers and share their drinks and go to the parks. It's just not okay. Those people are selfish. Those people are self-centered. Sorry. They're only thinking of themselves. If they catch the virus, then the virus is going to spread to their loved ones and other people who are really innocent bystanders to their terrible behavior. So there you go. Next. Yulana Pilpiak. How can management police indoor amenities like change rooms? Does each amenity need to have a guard, or can you post rules and residents police themselves? Well, another excellent question. So what are the indoor amenities? You're not going to be able to use the fitness facilities. Nope. You're not going to be able to use the sauna or the pool. Nope. You're not going to be able to use yoga rooms. The only thing you're able to use at the moment from an indoor perspective is the pool. From an outdoor perspective, it's the pool and a lot of the outside amenities. You can now use them, again, always with the conditions of social distancing and sanitization. I think it's unreasonable for management to be put in the position of a police officer. I think that there needs to, you need to, as far as a very heavily used amenity, I think that's the place where you need to keep your eye. So, for example, the swimming pool, that would be, to me, the place where you may have overcrowding, and you need to look very carefully at that. And, as far as the change rooms, well, you do the best you can. And what you do have control of is, of course, regular sanitization of the area. But again, those change rooms and those showers in the change rooms are only going to be available in combination with using the pool. So you've got to do your best to educate your owners. You've got to, as I said before, I think you'd have to send out a compliance letter or a phone call and then a compliance letter to those people that are not social distancing and following the regulations. And at the end of the day, it's got to go to the condo lawyer for further handling, and the last step is going to be, prohibiting those people from using the amenities. Remember that even though they're not practicing their social distancing and not doing what they have to do, the liability still will continue and cover the corporations and management. So it's not just that the fact that the owner is a buffoon or the resident is a buffoon. It also that buffoonery, that type of poor behavior affects the liability of management and the board and the corporation, because they are ultimately responsible for the care and control. Next. Sally, thank you so very much. Appreciate the great info. Robert Buckler, what should I do if a declarant wants to change or revise the budget before turnover to reflect actual expenses? Turnover has not happened yet, though they have sold over 50% of the units. So they've sold over 50% of the units. I'm going to presume there's no turnover. I'm going to also presume, I'm wondering if the condo corporation has been registered or not. And I'm wondering if it hasn't been registered, is this a disclosure issue? Because if it has been registered, it would be a different situation. So maybe, Robert, you could answer that question first. Next question, Andy Tom. Can we create a rule prohibiting alcohol use on our roof deck? We have had issues with people partying. Since we do not have 24/7 staff, we have no way of monitoring potential dangerous activities. So the simple answer is yes. You can create a rule. Rules are for safety and security. That's one of the reasons for rules. And this is definitely a safety issue. And a use and enjoyment issue. So 100% you can have a rule dealing with your amenities, of course, and including your roof deck, which is an amenity. And I suggest that not only should the rule deal with alcohol use, but other type of issues that you may have on that roof. And while you're doing that, you may want to look at all of your rules dealing with amenities and see if they are satisfactory. And just to add one other thing, and we had brought this up 2 weeks ago at the live stream, and there must be a lot of lawyers listening to this live stream. They're hiding their identity, of course, as condominium lawyers like to do. But 2 weeks ago, we brought up the issue of waivers and whether waivers would be appropriate or useful where condominium corporations were opening up their amenities. And if you will recall, a waiver is like a contract whereby the person signing it gives up rights to sue. So in other words, a resident would sign a waiver giving up the right to sue the condo corporation in the event that there was damages or in the event there was personal injury or COVID, etc. And that's one of the things that we brought up 2 weeks ago. And after we finished our live stream, the issue of waivers became the rage in the condominium industry. And so this is something that is an issue that I think all boards and managers need to look at carefully, whether waivers and appropriate waivers should be used when opening up or reopening the common elements. This is something that some corporations already have waivers. They've had them for years. A lot of corporations never thought about them, but they're good because you don't want damage claims or personal injury claims being brought against the condo corporation. Usually they should be brought against, if there's a third party contractor, they're usually insured, and so claims should be brought against them. Next, Debbie Pfefferman. Robert, I believe the declarant can increase the budget on registration by a certain percentage per year to reflect the actuals. This is set out in the Condominium Act, and it is normally, I've seen that before, the increases in the budget, and this is for new buildings. So yes, Debbie, I'm agreeing with you. Lich 22, regarding the pool with 30% capacity not comply, the 30% capacity is specifically for places of worship and for wedding ceremonies and for funerals that are held indoors. So unless you could somehow shoehorn in your swimming pool into a place of worship or a wedding, the 30% capacity will not comply. But Lich, I like the way you're thinking. You should have been a condo lawyer. Catherine Gao, can you comment on a condo corporation's obligations to respond to the buffering requirements with respect to light intrusion? The intrusion is into a next door neighbor's suite. Well, I can tell you this. If you've got light intrusion into a neighbor's suite, what you have is a nuisance. And there's a law of nuisance, and a nuisance is actionable. So regardless of the bylaw requirements, which of course I would have to review, the intrusion in and of itself is actionable as a nuisance. And everybody's entitled to quiet use and enjoyment of their condo unit or their property. And this definitely is what they call in law, it's called a tort, and it's actionable. GV, can you please let us know a condo corporation's obligations with respect to a guest suite? Well, the guest suite is an amenity. There is no prohibition on opening up the guest suites, so you can, but you need to, again, have a sanitized area. You need to have proper cleaning. You need to ensure everything is done accordingly so that there's no issues with respect to the virus. I would suggest for heavily used areas like a guest suite and a swimming pool, I would suggest that the signing of a waiver would be very important. Next question. Realistically, using pools inside and outside, who is going to maintain the contact tracing? Paulette, I have a job for you. It's going to be you. So contact tracing, everybody knows what contact tracing is. It's when people use the amenities, you find out their name and their contact number so that if, heaven forbid, somebody has COVID-19, then you can trace the people that were at the pool, in the pool, near close to the pool that day, and the health authorities can follow up with them. So contact tracing to me is important, something that the owners need to put out their name and their contact information prior to entering into the pool. So there should be a board there that you can put your name down, put your contact information. If you've got a lifeguard there, then have the lifeguard, be part of this protocol. Karen Slack, can we refuse to keep the outdoor pool closed for the full year and open next summer? Well, the bottom line here is the pool is an amenity. The condo corporation, the board, has the ability to manage the assets of the corporation, to manage the common elements. The board can, if it so desires, pass a policy, put in place a policy to keep the pool closed, and they can do that based on safety and security reasons. Yes, it's a service, but you can close a service, and there's a proper way to do that. But again, condo corporations need to look at their community and what's working in their community, and they have to all measure their own risk as far as safety is concerned and what their risk tolerance is. So I can only tell you this: the province of Ontario, they basically closed up the province. They're opening it slowly now, but there is nothing to say that a condo corporation cannot have a rule or a policy that is more strict than the province of Ontario. And I'm going to use as a specific example short-term rentals. Now, the short-term rentals, at a certain point, the Ontario government said you could not have any more short-term rentals during the stage 1 part of the pandemic unless they were for a longer-term use, for habitation, but not for hotel purposes. Then recently, and if you watched my live stream 2 weeks ago, the government then said, okay, fine, they're now going to allow short-term rentals, back in business. And I was very upset. And I know that Doug Ford, he's got to be watching this live stream, because whenever we make a good suggestion, he always follows through. And I said to Doug Ford at that time that it was a very poor suggestion to reopen short-term rentals during the pandemic. It made me particularly disappointed to see the Premier standing next to the Minister of Economic Development, when they announced that short-term rentals would be once again back in business. Now, their thinking was that people are having a hard time, and if you can rent out your spare bedroom, you can have a few dollars, and it would all be great. But what the Ontario government fails to realize is the problem with short-term rentals, especially in high-rises, is that there are many people that are renting out dozens and dozens of units for short-term rentals and have turned residential condos into ghost hotels. That is now illegal, to have a short-term rental which is less than 28 days, to have a short-term rental that is not the operator's principal place of residence. So those things are illegal now, and I found it was inappropriate for the government to give a carte blanche back to this type of business. Not a good idea. Next. Paulette. Important note I think to make is that waivers do not absolve the corporation of their duty to maintain a standard of care. So a waiver deals with negligence. And a negligence is when you fall below your standard of care. The waiver is a contract, as I said before, that takes away the right to sue. And I think, Paulette, the issue of the standard of care is really one of the reasons why people might want to have a waiver, because there's always going to be a question on, what was your duty and did you fall below your duty? I'm of the view, and I hate to disagree with a woman of your experience, but I'm thinking in my view, that you would have an issue on your hands arguing standard of care if a waiver had been signed. But keep in mind, there are many circumstances where a waiver may not be upheld in a court of law. When you sign the waivers, you have to ensure that the person who signed it read the waiver, understood the waiver, and that's why there's a lot of places on those waivers where you have to have the people, or should have the people, put their initials. They have to understand what they're signing, and they have to have the ability to read it over. Karen Slack. All right, we answered you. All right. Dreadbane. What if unit owners are challenging notice of lien after it's been issued and they want to waive that fee? Should we waive that fee? So I have a question for you. Why doesn't the unit owner pay the maintenance fees on time, and there would be no need for a notice of lien? Why does the unit owner need to be encouraged to pay their maintenance fees by the issuing of a notice of lien? So my comment to you, Dreadbane, is unit owners should pay for the notice of lien. They should pay for the notice of lien because they didn't pay their maintenance fees on time. And they were already in arrears of, I'm sure, at least 30 days when the notice of lien was issued. So if you take a position that you're not going to charge for the notice of lien, and the notice of lien was done by the manager is still going to get paid for doing the notice of lien. And the money from the payment is going to come from the operating fund, which all unit owners pay into with their common expense fees. So the question is, why should all the innocent unit owners who do pay their maintenance fees, why should they subsidize the legal fees for someone who didn't pay their maintenance fees? So as far as I'm concerned, unless there is a very compelling, unique circumstance, I would always ensure that the owner had to pay for the notice of lien. Again, if there was some compelling circumstance, of course, the manager and board could look at it, but most times there's not a compelling circumstance. One thing I have learned as a condo lawyer is that when owners say to you, I have no money, not all the time, but many times it means I have no money for you. For me, I have money, for you, I don't. So you need to encourage some owners that they must pay their maintenance fees because that's important to the health and well-being of the entire condo. Next, Danielle Kasha, known for her tremendous abilities as a condo manager and the very nice way that she speaks to everybody. What if unit owners are challenging a notice of lien? I'm flipped onto the wrong line. Brian, is utilizing a computer system such as condo control for amenity bookings sufficient for contact tracing? I'm going to suggest that if the condo control has the ability there to have the name of the people who are actually using the amenity, the answer would be yes. The question then becomes, are there people using the amenities other than the one who booked it? And therefore, if that's the case, perhaps the unit owners should be advised that they must go to the concierge, and if they are going to be using the amenities with any guests, etc., those guests, etc., their contact information must be put into either the system or into a log somewhere. Daniel Brooks, should the amenities waiver include an indemnity clause in the event the resident gets COVID using the amenities, or should it state use at your own risk? Well, I believe that the waiver should cover the COVID-19 issue as well as any other issue that may arise from the using of the amenities. So if we can go back in history before COVID, and I don't know how many people can actually think what life was like before COVID, but before COVID, many corporations would have a waiver, and the waiver would set out that you were going to be using, for example, the gym, the fitness equipment, the pool at your own risk, and that by signing this waiver, you're waiving any claims for damages or personal injuries, and you're indemnifying the corporation, etc., etc. So those waivers have been around and have been used in not only in condo settings, but in fitness settings. If you go to a health club, if you join a fitness club, I guarantee you, when you signed up, you may not recall, but when you signed up your membership, you signed a waiver, guaranteed as part of that contract. Take a good look and you'll see it there. So I think you should have both. The waiver should cover your usual personal injury / damages plus COVID as well. And to me, it makes sense because it's something that condo corporations should have thought about in the past. Many did, but many did not. And once you're doing the waiver, it might as well cover COVID-19, and other things as well. So that's what we have here. Again, we'll wait for a few more questions to come in, but as I said before, we're in stage 2. Things are moving ahead. Hopefully, it won't be too long until we're in stage 3. I will tell you that if all of us are not going to be careful in stage 2, we may rebound back into places where we don't want to go, where things will be closing up, that were opened. So maybe you should go this weekend quickly and get your hair cut. I will also give a shout out. I usually give a shout out in the live stream. So today's shout out is to all of the people of Ontario who have worked very, very hard, who have sacrificed much, who have worked tirelessly in closing their businesses, in reducing the things that they do, in maintaining social distancing, in leading a solitary life where they, could only communicate or have a social gathering of 5 people, now 10. And because of all of that, we've been able to slowly open up the province of Ontario. And we couldn't have done that without everybody's assistance. And I mean everybody who's listening to the live stream and all those that will be listening to the live stream. Of course, I exclude from my comments the COVIDiots who don't think about these things. Now, let me discuss one other thing here, AGMs, annual general meetings. So as you all know, the law for AGMs is that you must have your AGM within 6 months of your financial year end. We all know that, or should know, that one of the provisions in the regulations that the government of Ontario came out with was that because of the emergency order and the pandemic, AGMs, the time to have an AGM was going to be extended so that AGMs would have to be held within 90 days of the end of the emergency order. So that's the law now for the moment. What else came out was that you didn't need to have a bylaw in place to have a virtual meeting, and you did not need a bylaw in place to do electronic voting. And again, this is only during the pandemic, during the emergency order. You also do not need to have a bylaw in place, or you do not need to have unanimous consent of all board members if you're going to have a board meeting electronically. You prior to the emergency order, you needed to have the unanimous approval. So all these things are very good, and we are now starting to see slowly some condo corporations who've been waiting, and our office really had suggested, waiting till September to see how things were going as far as COVID, and before making a decision whether to have an electronic/virtual meeting, or whether we would be able to have an in-person normal meeting using, I guess, social distancing. So where we stand right now is that slowly some corporations are now saying, well, maybe we should be looking at having a virtual meeting, an electronic voting and virtual meeting. And so slowly some corporations are starting to do that. So there have not yet been a lot. There are a few different computer programs out there. Still, I think they all have certain glitches that everybody's trying to straighten out. And so I don't think we're 100% there on electronic voting and virtual meetings, but we seem to be going in that direction. And this is something that, I would think that they're starting to appear on my calendar. And as we hit September and get into fall, if we're still in the state that we're in, I can see more and more corporations moving forward with electronic meetings. I will also say that, you are able to, this is on another topic, you're there with certain provisions, you're able to go to drive-in movie theaters now. Of course, you can't get out of your car, and and you have to have your cars at least 2 meters apart, and you can only use the washroom, and for food services, it has to be brought to your car. So there's a whole section in the regulations about drive-in movie theaters. So I'm thinking to myself, as the creative person that I am, is that if you somehow package your AGM so that you could hold it in an outdoor drive-in movie theater, maybe that would be acceptable. So we have to think that through. We'd all be in our cars, and I guess to show our displeasure with the board and the lawyer chairing the meeting, I guess we would honk our horns. So we have to give a little bit of thought about that. Maybe that's the option to not having a virtual meeting. All right, last few questions. Nita. Hi, Brian. Do you need the electronic voting bylaw? Should the emergency order be lifted and the virtual AGM is scheduled within 90 days after the emergency order lift? So, do you need the electronic voting bylaw should the emergency order be lifted? So if the emergency order is going to be lifted, you will then need, you will not be able to have virtual meetings. It's only during the pandemic, and there's a period of time after the pandemic by which you can still have voting electronically and a virtual AGM, even though the emergency order has been rescinded. So there is, depending upon the date of that virtual AGM, there will be a carryover provision from the suspension of the emergency order until when you can no longer do the bylaw. Terry Firster. Terry, how are you? Brian, there is some suggestion that if the AGM date is set during the emergency situation, this will allow an AGM at a later date in visual format. Do you agree? So again, yes, you can set your AGM during the emergency period now, and there's a holdover period from whence the emergency order is rescinded for those AGMs that have been scheduled electronically or virtually. So the answer is yes, but there is a specific time frame for that. Paulette Forsyth. Brian, thank you again for sharing your time and knowledge with us. See you in 2 weeks. Nita G, thank you. Leo Alvarez, thank you, Brian. The song Tequila may be appropriate for COVID-19 pandemic time. Have a great day. Well, Leo, thanks a lot. And with that, we're going to end today's live stream. I will tell you that if you enjoy what you're seeing, please let us know. Drop us a line. If you have any suggestions, we're happy to accommodate those suggestions. You can subscribe to our YouTube channel. There's a button right there for you. And if you'd like, you would have the ability to get all of our information sent directly to your computer. So we'll see you next week. Bradley Chaplik will be hosting the live stream. And in 2 weeks, yep, I made the commitment. I better leave now. I got to go and practice. I'll tell you that right now. I got to start practicing because I want to make sure